Welcome to the Janus decision discussion. This seminar will provide an overview of how local governing bodies should handle the Supreme Court's recent decision in Janus versus AFSME. Our speaker for this workshop is Joseph M. Hannon. Mr. Hannon is an attorney with the law firm of Genova Burns, who practices traditional labor law on behalf of the firm's public and private sector clients. He is widely recognized as a leading authority in collective negotiations and a broad range of labor-related topics. I'd like to thank Mr. Hannon for being here today, and with that, I will turn it over.
Thank you very much. As I was introduced, my name is Joe Hannon. I'm with the firm of Genova Burns, and we represent a number of municipalities, counties, state of New Jersey, in a wide range of labor matters, collective negotiations. Happy to work with John with the NJAC and the League of Municipalities, and happy to be here at your conference to discuss this rather timely issue, and an issue that has come to the forefront since the summer on a matter that basically would largely go unnoticed prior to this summer based on the Supreme Court's determination in the Janus matter. Now, this came out in the summer. I'm sure that a lot of you have already taken the steps of not deducting dues for non-members of the union who are part of a collective negotiations agreement. But what I'd like to do is kind of go through the decision, go through the principal points that you should be concerned about as far as how to deal with these dues, what to do regarding withdrawals and consents to have dues withdrawn, and kind of explain the difference between what union members are, what non-union members are, what this applies to, and the works, and also touch on the effect of the new Workplace Democracy Enforcement Act has on some of these issues as well. And I want to hit it on a step-by-step basis so you have an understanding of it, and can move forward appropriately in the future with any claims. Obviously, taking a look that there may be changes down the pike, but so you understand where the current state of the law is in light of the Supreme Court decision, and then what happens going forward. I provided to you, hopefully everybody's able to get a handout. It's a 2-page question and answer. I'll kind of be going through those questions during the presentation, but I think it hits the principal points of what this decision is about, and hopefully could be a quick reference guide for you when faced with issues. Certainly, it's not the be-all and end-all, but it's it's a good primer and a good start on how to deal with these matters. So, to start off with, just so you have an understanding of where this was, in New Jersey, and this is the law, which is still the statute, but prior to the decision, you had the law in New Jersey, which was NJSA 3413A-5.5, and it provided that representation fee in lieu of dues would be your regular membership dues and the initiation fees and assessment charged to regular members, less the cost of benefits financed through dues, fees, and assessments available to only to its membership, but in no event shall exceed 85% of the regular membership fees. This 85% representation fee in lieu of dues is kind of the standard that you see in a lot of collective negotiations agreements, and is what was utilized in determining what these dues are. Now, the one thing to be clear upon is that this deals with individuals who are covered by a collective negotiations agreement based on their title, but who choose not to be a union member. That's what the Janus case was about, and I'll go over the facts of that case, and then we'll keep going back to these principles throughout the presentation. But it's important to understand those distinctions in understanding what Janus actually meant. So in Janus, this is a case from Illinois, and Mark Janus was a child support specialist for the Illinois Department of Health Care and Family Services, and his title was part of a union. And that union was the American Federation of State, County, and Municipal Employees, which we all affectionately know as AFSME. I'm sure a lot of you deal with AFSME in your municipalities. And in this case, Mr. Janus was not a union member, but obviously reaped the benefits of the collective negotiations agreement. You know, grievances, raises, all that stuff was covered by the collective negotiations agreement, but Illinois law, much like New Jersey, was that he was compelled to pay an agency fee, a mandatory agency fee, in lieu of dues. So, as you know, there's the payroll deduction, and whatever the case in Illinois was, or whatever the agreement was between the non-members and AFSME, a percentage was automatically deducted from Mr. Janus's pay without consent, without any real choice to Mr. Janus. So, based on that situation, Janus, with support of the governor of Illinois, initiates a court action in federal court challenging this law. I'm not going to bore you with all the procedural details of the case because it's not law school here, but the point is that what the case makes its way to the Supreme Court. For obvious reasons, this is an issue that was of great concern, you know, politically as well as legally. And what the court had before it was a matter called an Abood case from the 1970s that upheld these representation fee in lieu of dues, or agency shop fees. I'll kind of interchange them. I mean, I think agency shop fees or agency fees is a lot quicker to say, so that's what is meant when I give that term. And what the Abood case said, and what was the principle behind permitting this agency fee, was that there was a need to have these automatic deductions in the union workforce. And the two principles behind it was, you know, one, labor peace. Okay, you have unions, they have an exclusive representative, they are coming forth to negotiate matters, and in labor peace, it is always easiest to have one voice representing the workers for union negotiations and prevent factionalization of people sprouting out from the union and then having different voices to be heard in negotiations. The second issue was the fear of the free rider. What does a free rider mean? Well, it's the individual who is reaping the benefits of a collective negotiations agreement without paying in for it. Because whether you want to be a union member or not, your title is covered by a collective negotiations agreement. So anytime the union negotiates a wage increase, just because you're a non-union member doesn't mean you don't get the increase. You get the increase. If you're disciplined under the grievance procedure, you would get representation. You don't get thrown to the curb. You know, there are work rules, health benefits. All that stuff is within the collective negotiations agreement, and the Supreme Court concern was that if you let individuals choose whether they would pay 100% union dues or nothing at all, you would have individuals, essentially the individuals who are choosing to fund it and be full union members, footing the whole bill for other people who are essentially getting the benefits as well. And that was the principle that was upheld kind of unchecked for many years, and those are the legal principles behind it. You know, whether you agree with it or not, could be a legal decision, could be a political decision, but those were the concepts behind the Supreme Court decision. And, you know, as you know, there are, you heard the term on the news, right-to-work states, you know, those where you have the choice, you had the choice, so there were certain states that you weren't required to pay agency shop fees, but then in New Jersey and many other states, including Illinois, there were laws on the books that we have that required it. So with that backdrop, the Supreme Court gets the issue, and of course we're here today because they reversed the precedent in the Abood case and essentially made it, talked about the free speech implications of it, about not being compelled to pay for something you choose not to be a part of. And so the result is that agency shop fees that are involuntary are no longer constitutional per that case. And that changes the landscape of what happens here. So basically come this summer, I'm sure I don't need a show of hands, but you could probably understand that who doesn't have individuals who choose not to be a union member. I'm sure everybody has some places. Especially the bigger places, you're going to have individuals who choose not to be a union member. They were getting dues deducted, all right? That changes the game for them. So, in the handout that I provided is, and I'll try to get through some of this stuff, what did the court rule in Janus? The main thing is, and it was a 5-4 ruling on, I guess, pretty predictable slants, determined that the involuntary payment of an agency shop fee by non-members of a union is unconstitutional as a violation of the free speech rights of those employees. The key terms in there are involuntary payment, all right? Been over it, but that's the key issue of non-members of the union, all right? So that is what was overturned, and here we are today dealing with it. Now, what are agency shop fees? We went over it, but this is kind of a quick definition there, that if a majority of employees in a negotiation unit vote to be represented by a union, then the union is the exclusive representative of all employees covered by the collective negotiations agreement. Really what it is all titles covered by the collective negotiations agreement. All right, so if I'm in a PBA, I'm a police officer, I'm covered. All right, if I'm a clerk, a secretary, what have you, and that title is part of a negotiations agreement, my position is covered by the agreement. All right, the way public sector is in New Jersey, almost all these titles, all your municipalities have your workers unionized. Okay, that goes through PERC, and you've had elections on that, and those titles are now part of the union. So whether those individuals choose to be a union member or not, and I'm not going to go through all the representation issues through PERC and the authorization cards and things like that, but you have individuals who are part of union and not. So the collective those involved in the collective negotiations agreement includes employees who choose to be members of the union, and those employees who are part of the collective negotiations unit due to their titles, but who choose not to be union members. Okay, so just as I explained. Those individuals who choose not to be union members pay the agency shop fee. So a very important thing to understand in this is, the next question is, did the Supreme Court decision in Janus affect those members who are part of the union? I know I'm kind of repeating myself, but the quick answer to that is no. All right? Anybody who was regular dues paying members, who are paying the 100% fee, the 100% union dues, they are not affected by Janus. All right? And I think by now everybody should know that, but I know early on when this first came out, that was an issue I know had to explain to a lot of places and clarify who this applies to and who it doesn't. Then you look at how agency shop fees were covered in New Jersey prior to the Janus rule. And it was, as I said at the outset, you have the provisions of 13A 5-5 to 5.8, which talks about the payment of agency shop fees and what is covered. It's what the regular, in a nutshell, the definition's there. In a nutshell, it's what a regular union member pays minus fees that are not dealing with essentially contract administration, essentially political activities. And that's supposed to be deduct it, but in no event could be more than 85%. So, the weird thing about this in dealing in public sector negotiations and contracts is, I've been doing this for many years now, and this is an issue that's been so entrenched that you really don't ever deal with it. I mean, it's part of a contract, dues are deducted, there is an appeal mechanism within PERC to challenge dues if a union member feels that, or if a non-member feels that their fees are not adequately represented by the appropriate standard that's supposed to be used under the statute, there is a process in place in PERC to challenge it. I've never been a part of one of them before. I don't think they're too common, but the appeal board exists. It's there, and it's. But like I said, it's largely gone unnoticed. The contract terms. I mean, you never sit at the table and say, we want to talk about your demand and return system or your agency shop fees. I mean, it's been pretty standard, but now, really, what you need to do in looking at it is you have terms in a collective negotiations agreement. You have 85% in there. You have a system in there regarding how fees are to be deducted, and they really need to be re-examined in light of this decision. I mean, you need to kind of really dust it off, because that page probably has a lot of dust on it. Take a look at it, see where it's at, and see where to move forward on. And we'll talk about some of those issues as well. But it's certainly some new territory that you have to deal with. So now getting to the real meat of what it is, because that's obviously what happened here as far as the overturning, is what happens to these non-union members after this decision. How do you deal with it? What did the court say that you as employers, and of course most of you as finance officers who are going to be charged with dealing with these issues and these withdrawals and what have you, how do you deal with it? How do you process it? What are you looking for? What can you do? What can't you do? And I think there's a few main concepts that you need to be aware of that we'll go over here. And I'm going to skip to number 6, is how should public employers handle agency shop fees that are currently being made to employees' paychecks? Well, we're a couple months in, but if there are individuals who were making these involuntary payments under the prior law, that should have ceased with this opinion, because it's unconstitutional to do that. So if it has continued, if you didn't hear from the union and you just continued to do it, really that is not, it's not legal under the Janus decision. So certainly make sure that that's the case. Make sure that anybody who is a non-union member is not having those representation fees, those agency shop fees, being deducted absent consent, which we'll talk about what the consent is. Okay, so that should have been a step that was taken, whether it be through the union making that step, or you reaching out to the union saying, listen, we're going to do it. That should have happened already, but if it hasn't, you really need to comply with the law in that regard. So the question then becomes, can non-union members pay any type of fee, any type of agency fee under the Janus decision? And the answer to that is yes. Agency fees are not prohibited. Involuntary agency fees are prohibited. All right, and that's an important distinction. So it doesn't mean that you're no longer going to have to do it. It's only going to be union members. You just have to have the consent. And so the question 5 there is, any fee structure permissible for non-members of union after Janus? The answer to that is yes. It was invalidated, any involuntary fee from non-members. However, the court stated that an agency shop fee may be deducted if the non-member affirmatively consents to pay. All right, so you have to have clear evidence of an affirmative consent to pay. And in order to satisfy the criterion, the non-member must clearly and affirmatively consent before any money is taken from them. Of course, we say they recommend some kind of written form. I mean, if a deduction is going to be made, you want to make sure that you have something in writing from that employee signing off that I permit agency shop fees to be deducted in the amount set forth per the agreement between my union and me, and then you could go ahead and go forward with the deduction. Now, the decision in Janus doesn't necessarily say what that must say, what type of form it should be. It just talks about an affirmative consent. So I think something in writing that clearly has that you could put in the file, that you know when you're making these deductions that it's there, I think is necessary under the decision. The trickier question becomes in number 7 in the handout: how should notice be provided? How do you notify individuals if they are being, if the agency fees are being deducted? And, in tandem, or not in tandem, prior to the Janus decision, the WDEA came out, the Workplace Democracy Enforcement came out. Been heard it called other names, but for here, I'll call it the WDEA. And it's essentially the Union Access Act, and it came out prior to Janus. It certainly came out in anticipation of Janus, and it gives union access to employees and creates penalties for employers with interrupting with union activities and union access and right to join a union. Now, we'll go into some of the stuff regarding unfair practices with union access and the like. I mean, from my perspective as a management lawyer, my feeling was you already had the Employer-Employer Relations Act, which had provisions which not to interfere with union activities and protected union activities. So, certainly from that advocate standpoint, you felt that, well, PERC already told management what they can and can't do as far as getting involved in union issues. But this came out, most likely in anticipation of what would become the Janus decision and trying to assist unions in getting access to employees and making sure that, employers don't get in the way of that. So with that law in effect, even though the fees cannot be collected, it is important to understand that that direct contact with the employee is never a good idea. So really, as far as, when you did that and continued communications of this type of issue, probably always best to go in writing, go through the union head, put that down, say, listen, we are going to begin to, we're no longer going to deduct these fees based on the Supreme Court decisions in Janus, therefore, effective immediately, they will be ceased. I know in a lot of places, I had clients send me, unions were reaching out. Unions had their stuff prepared and said, please stop paying the fees, because of course, while it's difficult on us, I think it would also put the unions in a tough situation if we were deducting fees, agency fees that did not have consent, and then they were improperly getting money, and then they'd have to reimburse the membership. So it should be a headache from them, although having said that, I also know that unions weren't all fine with the type of notices that were going out. So you got to be careful in light of the WDEA how you communicate these type of issues. I think going through the union president, the shop stewards, the representatives, and acting in accordance with the law is always the safest and best way, so you don't get hit with some kind of charge somewhere that you then have to waste money on defending. The next issue is, what if the union or employee advises that they would like the agency shop fee to continue to be deducted. Is that appropriate? Well, I think in light of what I'm saying, it depends on how that's coming to you. A fee that is involuntary is unconstitutional, as we've learned. So no fees can be deducted unless non-members show by clear and compelling evidence that the non-member is consenting to the fee deduction. So again, if an employee comes up to you and says, I want the agency fee reinstituted, if the union shop store comes up and says, hey, you know, I have these 6 people who want them deducted, if you have the agency fee, if you have the shop steward and all 6 employees come up to your office and say, we want this deducted, tell them to put it in writing and get that agreement so you could start doing it, all right? Because that's what you're going to want to have in place so that you could then do it. I mean, that's the key. It just can't be, I mean, it's new, but and there's a couple of simple concepts to it, but it can't be involuntary. So you want to be clear that if somebody brings a challenge, you could say, no, it was voluntary. Here's what they signed. Here's what they provided. The next issue concerning it is what is the appropriate amount for a voluntary agency fee after the Janus ruling? And that is not clear, because the decision itself doesn't talk about what's an appropriate amount. Doesn't say, you know, they talk about the way the Illinois law was and what happened and what the amount was in Janus, but it really, that issue doesn't necessarily go to, here's the formula, here's what you have to use. I mean, the formula, what you see in the Employer-Employee Relations Act right now regarding what an agency shop fee could be was taken from the U.S. Supreme Court, and that model has been utilized. So, you know, my best advice on this, our best advice on this, is that the Employer-Employee Relations Act provision regarding what can be included in an agency shop fee, not to exceed 85%, that is still a statute on the books in the state of New Jersey. So as far as what an appropriate fee would be, unless somebody challenges it, I think as long as it comes within the confines of that statute that is still on the books, then that's an appropriate fee. So if somebody comes to you with a fee that's equal to 90%, well then no, it says it has to be, you know, less than 85. It's 85 or less, well then, you know, that's the agreement between the employee and the union. And I guess at some point, if the employee feels that, you know, the union's getting way too political on things and not representing their interests and the fee's too high, well then they can go to that PERC appeal board and challenge it and go through that route. So I think that's the appropriate method of dealing with it. So for these agency shop fees, I think the key is that if anybody is having their fees, if anybody continued their fees after the ruling, that they should be removed. But if they want to continue, you want to have that consent in writing. And then the amount for it comes within the Employer-Employee Relations Act. And I think those are the principles that you need to have moving forward. With that, so I think that's kind of it in a nutshell as far as how to deal with the agency shop fees going forward. But there are other tricky issues concerning this going forward for contract administrations, because of course, you know, the fees deducted is one thing, but then, you know, public employers need to be careful that the fee that is being deducted, and whether they're a union member or a non-union member, does not confuse you in the contract administration and how to handle employees. And that's really, from a labor employee standpoint, my bigger concern about it. Just based on some feedback I had about, well, how do we deal with these individuals now if we're going to discipline them? How do we deal with these employees now if they have a grievance? And those are good questions. But I think the advice is simple advice on that. You treat them like you always treated them in that regard. Don't B, don't worry about whether they're having, if they consented to the agency fee or not. If their title's covered by a collective negotiations agreement, they still have the rights and protections under that collective negotiations agreement. And I'll go through a couple things with that. I mean, whether they get representation from a union, that's a different story, okay? And that's something that, listen, that's between them and their union. And the Janus case talks about some of those issues as well. So an employee, even if they're not paying the dues, if there's a provision under collective negotiations agreement that's been violated for that employee, a grievance can still be filed. The union could decide to file a grievance on their behalf, okay? If an employee is going to be disciplined and you're having a conversation with them and they ask for a union representative, they invoke their Weingarten rights, right, and say, I want a union representative here. Don't say, no, you don't pay agency shop fee, so I'm denying that because you chose not to be a member of the union. They still were non-members of the union prior to the agency shop fees, okay? So you grant them the right to a union representative. Now, so that's, I think, simple advice, but don't get confused by that. Now, some of you may not be dealing with those type of issues, but I think some of you will as well. And you may be dealing with some employee discipline or be involved in the grievance process. Let them determine who their representation will be. We stay the course on how we deal with it and respect the agreements and those rights, if you will. As far as it goes, and an interesting thing to look at going forward is as far as fees for these services, the court in Janus talks about the ability for the union to charge non-members for discipline, for grievance administration, meaning that the union can still represent these individuals, and if they choose to be, listen, if you're paying your regular union fees, then all that stuff's covered. You'd agree to that, but if you're not, the Supreme Court gives unions the right to charge. So, okay, you don't want to be a union member, and here's one way that I think unions can stay viable, because we'll talk about the future of that. And listen, that's you know, I know there was an article, I saw an article in the Ledger, I think it was in the Sunday Ledger, or one of the recent, about what's happening with the union membership in New Jersey. It's too tough to tell, numbers aren't in, unions are saying it's had no effect. I find that hard to believe, but maybe it's not having as devastating effect. I mean, we'll see when the numbers shake out as far as what's happening. But a union can charge. So maybe, you know, what could happen is, okay, non-member gets fired, union doesn't represent them because they're not paying the fee, they get terminated, or they're charged a high rate that the employee can't afford. You have some of that happening, and union members see that, may bring people into the fold, say, wow, you know, it was nice to not pay that fee when, you know, I was, you know, doing my job and getting the benefits, and, you know, but you know, didn't want to be part of it because I didn't want money for my paycheck, but when the chips were down, it was kind of good to have that. And so maybe that's a way that unions will gain membership, because really, when you look at the issue of what happens in those situations, that becomes an issue between the union and the employee. So you'll go forward with what you have to do, and we'll see what happens in that regard. Next question is, how should a public employer handle a situation in which union members seek to withdraw from the union? Now, this is not Janus. Okay, Janus is the agency fee. But one of the side issues to that is, okay, we've covered what exactly happens with the non-union member, how they get in, how they get out. But what happens with union members wanting to withdraw? And we know that the Janus decision doesn't affect union members as far as what they pay. And that's an issue that, although not covered by Janus, is covered by the Workplace Democracy Enforcement Act. And when I said before that the WDEA was drafted and passed kind of in anticipation of Janus, one thing the WDEA did is they changed the time frame in which a union member can withdraw from a union, essentially making it more difficult for a union member to withdraw from a union. All right, the law previously was that you could withdraw at any time, and then it would be effective the following January or July. So I didn't draft a bill, but obviously the contemplation was that there could be a groundswell of withdrawals from unions after this Janus ruling. Wait, I don't have to pay anymore, and I still get the benefits? And it was one thing when it was 100% to 85%, didn't really think much about it, but now I can go from 100% to zero and I still get those benefits. I'm gonna get the heck out of here. And obviously that's the big fear from unions and the big fear across the state and nationwide as to what could happen to the viability of unions in that regard. So certainly you can't foreclose an individual from seeking to withdraw from a union. I mean, you can't be in there for life. I mean, that obviously wouldn't be upheld. But the one thing that the WDEA did is said that withdrawal can happen within 10 days from your anniversary date of employment. That you could provide written notice within 10 days of your anniversary from employment, and then it's effective 30 days thereafter. So obviously, that limits the amount of time in which a union member can withdraw. It gives it to a specific time in which this could occur, and it's a moving target for everybody, so I think it could be obviously more easily missed. And it also, in light of, let's face it, in light of the Janus ruling, certainly gave breathing room to prevent a mass exodus. Now, whatever the policy reasons are behind it, these are some issues regarding it, but it just must be known that that's the process that has to come with the union withdrawal. Now, so if you get any of them or comes across, you got to make sure that they're complying with that provision of it and move forward there. So, what will this do? I'm not really looking. Has anybody seen a drop off in their union membership at all? Anything significant? Pretty much status quo from where it is? Okay. Yeah, we'll see what happens there. Listen, New Jersey has always had a strong union presence, especially in the public sector. So I don't think that we'll see what happens there. I know that unions were really planning for this and looking to educate their membership and constantly communicate. With the WDEA, have any of you had negotiations? I'm going to skip to the WDEA for a second because we have a little more time. Have any of you had negotiations under the WDEA? Have any employee that you're aware of? Okay. Because it gives, there's a lot of, I'm starting to get a lot more questions now about, what type of access should I give? They want to do this. They want to meet during non-work breaks. What's a non-work break? How is this defined? So that's something that's new and will have to be looked at as well. And you have there were proposed regulations that came out regarding the WDEA that's kind of mirrors the statute, but we're taking a look at that are due in November. But dealing with unions in light of WDEA, in light of Janus, there could be changes there. But as I said when we were going through the contract, is that you got to make sure that communications are such that you are not looking to interfere with the union relationship. And I think one important point in the WDEA is that there's a provision that says that a public employer shall not encourage negotiation unit members to resign or relinquish membership in an exclusive representative employee organization, and shall not encourage negotiation unit members to revoke authorization of the deduction fees to an exclusive representative employee organization. The next provision, a public employer shall not encourage or discourage an employee from joining, forming, or assisting an employee organization. So that's good. I mean, at least they recognize that that public employers shouldn't be pushing people into a union. But, I mean, that's as blatant as you could say, not encourage or discourage. I think the clear view of that is stay the hell out of the way, all right? And what I mean by that is no one's obviously going to say, hey, you know, you get out of the union, you should do that. I mean, I think we're all mindful enough of that. But, you know, one question that came up with the client was, hey, you know, employee asked me that, you know, that they want to withdraw from the union, and, you know, can I send them the information or the law regarding how to do it? Now, if you send somebody saying, okay, well, you know, here's your question, just trying to be helpful, you know, here's the statute. In and of itself, it seems benign. I'd be very nervous in going down that route because you're providing information. Perk, they're going to look at that. Is that encouraging or discouraging? I don't know. We haven't had a decision on this yet. But I know what the impetus behind the WDEA is. I know what the feeling is, you know, with Janus and that trying to protect it. So, you know, in your standpoint, if you're getting innocent questions from an employee regarding these type of issues that seem to be like, hey, you know, yeah, here's the law on it, or, you know, listen, if you wanna, you know, or the other way, listen, if you want to continue to have your agency fees, like, come to me with a written form. The best thing to do is say, can't answer, consult your union rep on it, all right? You know, we got plenty of work, don't want to necessarily be representing these type of claims that, you know, the type of situations I'm saying, like they said, they're pretty benign, but you know that, you know, I think in this climate, and in light of the Janus climate, you know, I think unions are certainly mindful of the fact that they need to show that they are fighting for their membership. All right? We have value. This is what we provide. You know, we provide this service. We'll fight for you. You know, we're not going to have the employer, you know, violate your rights. So, you know, I would be mindful of that type of attitude going forward, and making sure that, you know, you're not, because they, you know, a lot of people out there want to put meat behind the WDEA and what it means. And, you know, some of this stuff, you know, might not be a big penalty at the end, might be a who cares, but it's probably just best to kind of stay away from those issues, let the union handle it, know that these are their issues, not your issues for the most part. You just got to make sure that you calculate it correctly and that you follow the provisions in the law. So hopefully a decent amount, since it's been out there for a couple months. You guys have already been dealing with it. Hopefully, you know, a decent amount of what I said was kind of review and things that you're already doing. And if so, that's great. I mean, that's, you know, you want to deal with it. But, you know, just be mindful, as it's not just a calculation. Some of these side issues regarding WDEA and union issues, they are kind of some side issues, and there's probably some others that'll pop up that I haven't discussed today to just be mindful of in your conversations, in your dealings with your employees, and your dealings with your coworkers and your managers and your administrators and your council members, if you will, and make sure that, you know, you stay in compliance with this, and keep an eye on what changes will happen, because you know, this is an issue that, like I said, we kind of dusted you know, we dusted these sheets off, but, you know, now it's out there, and you're going to see change in this area. You know, we'll see what happens in the future. Take a look at your collective negotiations agreement, consult with your counsel, make sure that, you know, that's up to date, and you know, and good luck going forward with this. I have a couple of minutes if anybody has questions, but I kind of have exhausted my information for today, and enjoy the rest of your conference. I'm really happy to be here today. Thank you.